Welcome to Sakshi Manasakshi. I am Priya Goteti. Welcome to Sakshi TD Special Immigration Show with Attorney Ms. Prashanthi Reddy from Law Offices of Prashanthi Reddy PLLC. Please tune in to ask your questions. If you are an immigration attorney and would like to join our shows, please call 866 2725 7441 or email us@sakshi.com. Before we begin the show, please know that the information provided on this show is not a legal advice and for general information purposes only. Sakshi TV or its agents will not be responsible for use of this information. If you need specific legal advice, please contact the attorney directly. So without any further delay, let's start our show. So hi Prashanthi ma'am, how are you?
Hi, good, thank you. How are you?
I'm good, thank you. So can you please provide information on your law offices, practice areas and your experience?
Yes, my name is Prashanthi Reddy. I'm an immigration attorney with close to 24 years of experience. We specialize in business immigration. We also do family immigration. And we are located in Midtown Manhattan, close to Penn Station. And if you need to reach me or look at my website, it's www.reddyesq.com.
Yeah, thank you Prashanthi. Do you have any latest updates for this week?
Yeah, I think we can start with the topic of the hour, which is the policy guidance, right?
Yes. H1B extension difference.
Yes. So if you permit me, we could start with that. That is the update, actually.
Yeah, sure. Go ahead.
So I guess what happened a couple of days ago is that USCIS has gone back to its earlier policy guidance with reference to extensions, not just H1B extensions, but all extensions that you file. It could be an L1 extension, it could be a H1 extension, whatever extension you're filing. Just to backtrack a little bit, previously there was always difference given to the previous, if an extension, that means you filed it before. So to the previously if it was approved, then they don't ask too many questions when you're filing an extension if it's between the same parties and nothing has changed. And if it was not given in error, then what they used to do prior to 2000, as per the 2004 memo, they used to give deference to their previous approval, to the previous decision that they made. So usually we never used to get too many RFEs on extensions. And this was especially useful for L1 extensions because, filing an L1 extension is difficult if they go through the merits of the case again. But what happened is in 2017, under the Trump administration, they rescinded that memo, and they started not giving deference to their previous approvals. So they would ask everything again. Even if it was an extension, they would ask right from the beginning. Though nothing has changed, for example, in a H1, nothing has changed. It's an extension, same employer, same client, same beneficiary, same company. But then they will again, and for example, if you filed for a software engineer and they've already made a decision that it's an approvable case, they will ask everything all over again and send a 7-page RFE asking for specialty occupation, how the education of the beneficiary is related to the job, etc., etc. So those RFEs were ridiculous and very time consuming and especially difficult in certain circumstances. Mm-hmm. So now that that has happened, there is again difference to previous approvals, previous opinions from USCIS. It becomes much easier, and it becomes easier especially in cases where it's a difficult case to start off with, where it's a specialty occupation, where maybe the job title is kind of borderline and it may not really qualify for a specialty occupation, but we have shown with all the paperwork that it does qualify. Say you're doing it as a computer programmer. There are some jobs that don't qualify, and USCIS has to, pay more attention and go into the details of the job description. So if we've gotten an approval like that previously, and then now we're filing an extension, sometimes you might have to file an extension a year later. Because, previously USCIS was issuing H1s for only for a year. They're not giving the entire 3 years
Yes.
on their extension in some cases. So having to prove that all over again, and became a problem. So now we can avoid that. So once the person is on H1, they'll continue to be on H1. When you file an extension, it won't get denied again, hopefully. Same thing with an L1. An L1 is always difficult to prove. You have to show that it's a multinational executive if it's an L1A, that he meets all the standards, and usually they give L1s for 1 year, especially if it's a new company, and then you can file an extension for 3 years. So when the extension comes around, it becomes much easier if they give deference to the previous fact that they approved it under the same job, same duties, becomes much easier. So those are the few situations in which this H1B deference law can help us.
Yeah, thanks for the update. And today we'll be discussing on general questions on H1, L1, I1, I-485, family and employment-based immigration, and also on H1B extension difference. So this is like a common question. If a person is in second year of H1 and planning to apply for a green card, what is the best way to apply to get it at earliest?
So if they're in the second term of their H1, so 3 years is over, now they're in the next 3 years. So they have to file as soon as possible. I mean, the only advice I can give them is don't wait until you find an employer that you like or you think you're going to stick with that employer for the next 3 years. It's not necessary. Just file with whichever employer you're with as soon as possible so that you can at least maintain your priority date and at least you can get an I-140 approval. Now, when you move to a different employer, you can still use that old I-140 approval to get your H1 extensions beyond the 6-year limit. So it's not necessary, the mindset does not have to be that, oh, I will only file for a green card if I intend to stay with this employer for 10 years or whatever, even 3 years, because the labor in I-140 takes about a year and a half. So as long as you are willing to stay with the employer for a year and a half, go ahead and file that labor in I-140 because your priority date will then be ascertained. You will be in line. And you can keep using that I-140, transferring the priority date. Even if you don't file immediately the green card with the next employer, you can continue to use that I-140 that you got from the previous employer to file further extension. So my advice would be to get onto that green card bandwagon as soon as you can and don't wait if the employer is willing, and don't wait for your dream job to do the green card processing.
Got it. For suppose if a person works on in a LLC on H1B, and recently the company has planned to issue some stocks which makes him a member of LLC, that makes him a self-employed, and can he do that?
So yes, because you can own shares in the business. I'll just give you an example. All employees of Microsoft own shares in their business because they offer them shares as part of the 401k plan or benefits plan. So that doesn't mean that there is no distinction between the employer and the employee. They can still file a H1 through Microsoft. So it really depends on what the shares that you're owning. Do you have control over the company? If you own more than 50% of the shares, and if it's a small corporation, then, and if you have control, that means you have control. If you have more than 50%, then it might be difficult to get your H1B approved through the same company, because then it kind of becomes difficult to distinguish between or differentiate between the employer and the employee. You might be the employer as well as the employee. So that could be a problem where, in the H1B scenario. So as long as you don't have control and you don't have majority shares or even a large chunk of the shares, you should be okay getting a H1.
Yeah, got it. So after this 6-year term on H1B, can a person switch to F1 easily? And is that there any limit on it?
Yeah, so this question often arises when they have not filed the labor cert, or you've started the green card process, or maybe they have but they started it late. So they find themselves in a situation where the I-140 is not yet approved, but their 6 years on the H1 is expiring. So then they have the option of either changing status as you said, to an F1, or leaving the country, biding their time until the I-140 gets approved, and then coming back, on the H1,
Mhm.
filing, because they're able to file beyond the 6 years. They're able to get an additional 3 years term because of an I-140 approval. But if they don't want to leave, such as now during COVID time, nobody wants to leave because it's difficult to come back once you leave because of flight restrictions, because of health reasons, and also because the consulate is closed.
Got
So
it.
in such a situation, I think the person would either would have to file a change of status in order to remain in the country while their processing of the green card is going on.
Mhm.
So usually they opt for, you could do a visitor's visa or you could do an F1 visa. So if you choose to do an F1, that might be problematic because when you fill out the I-539 form, there is a question, have you ever filed an immigrant petition? So if you're in the labor stage, you can answer no safely because the labor is not considered to be an immigrant petition. But if you have an I-140 pending, then you'll have to answer yes, in which case your F1 will not be approved. So it depends on which stage you're in as to whether you can change to a different status or not. And also you have to take into consideration that when you're filing an F1, your classes should start um, at least within 30 days of expiry of your I-94. That is another thing that you have to keep in mind. So
Mhm.
that might not be suitable for everyone because maybe no, not all universities have rolling admissions. Admissions start at a certain time. So that's another thing to keep in mind when you're filing a change of status to an F1. And also another thing is if you did manage to get an F1, now you have an F1, your I-140 is approved. If you try to travel on that F1, you might have a problem because again you have an intent to immigrate. So you'll have to file a change of status to a H1 immediately. You can't linger on that F1 once your I-140 is approved. You might even have a problem if you're on an F1 applying for an OPT or you're transferring schools. Anything that you do with USCIS, you could now have a problem because you have an I-140 approved. So you do not want to remain on that F1 status. You want to file for a change of status as soon as possible to the H1. The good thing is that you're not subject to the cap. So that's a good thing that you don't have to wait until next October and then remain in F1 until next October. You can file immediately because you were previously counted towards a cap. So there's a few things to remember when you file a change of status to an F1 to safeguard, your stay here and wait out that period for the labor approval or the I-140 approval, whatever it might be.
Mhm. Just a follow-up question, Prashanthi. If a person already utilized his maximum limit of 6 years on H1B, then he moved on to F1 visa. So next time when he's filing H1, it will be like a renewal, or is it like a new petition? And whether he'll get like 6 years again maximum term?
So it's a change of status. When he files again from an F1 to a H1, it's a change of status application.
Mm-hmm.
So the beneficiary cannot start working until the petition is actually approved. So it might be a good idea to file premium processing since it's not a transfer. If it is a transfer, then as you know, you can work as soon as the petition is received by USCIS. So it is not a transfer, it's a change of status. So that's one thing to keep in mind. And if you have an I-140 approved, you can continue getting 3 years extensions on your H1. There is no limit of 6 years now. Once you have an I-140 approved, you can continue extending your H1, but in 3 year intervals. You can't file for a 6 year extension at one time.
Got it. Got it. So if a person is a graduate and a labor is filed under EB3 category, but if he has more than 10 years of experience, is it possible to file another labor under EB2, and EB3 is going to take like more time, right? So can he do that?
Yeah, but in that situation, yes. So if you are moving from EB3 to EB2, you have to file a new labor. You cannot, because most probably your labor does not qualify you for EB2 because you're going up now. You're not going down. If you're going down, then you can file EB3. There's no problem. You can just file an amended petition or a new. I think more better would be to file a new I-140. So you have both EB3 and EB2. So to give you an example, say you asked for a bachelor's plus 5 years or a master's, as the requirement in your labor. So and then you file for EB2. In that situation, you would also qualify for an EB3 because being overqualified is not a problem. So you would qualify for both EB3 and EB2 at the time of filing of the I-140. You can decide which category you want to be in, or you can file a new petition and change it. But if you, as you said, filed for EB3 and you asked only for a bachelor's plus 2 years of experience, you don't automatically, you cannot amend that to an EB2. You have to file a new labor. So yes, you can file a new labor, but you have to go through the entire process again of advertisement and wait for that, do the prevailing wage, then wait for that to get approved. So it could take for the labor to get approved, about 10, 12 months. And then again, you can file based on the new labor for EB2, but by then your priority date may no longer be current. So that's something to keep in mind.
We have first caller, Raj from Chicago. Hi, Raj.
Hi, Priya.
Hello.
Hello.
Yes, Raj, go ahead with your question. Yes,
yeah,
please go ahead with your question.
Okay. My question is in regard to the firm with the green card. So I work for a consulting firm, and they did file my perm I-140 and also 485. My I-140 is approved and my 485 is past 180 days. But the problem that I have is my perm is for a specific location and they did not include any travel requirement. So would that going to cause any issues going forward because I don't work at that specific location?
So once your I-140 is approved and you cross the 6 months period on your 485, that means 6 months has elapsed since the time of filing the 485, there's a new law which comes into place, which is AC-21 law, which gives you flexibility to change to any employer. And that employer does not have to be within the geographic area of mentioned in your labor cert, right? So as long as you qualify for AC-21, you don't have to worry about working within the same geographic area. Does that answer your question?
Okay. Yeah, it does. But during the interview, would they ask why you did not work from that specific location?
No, so you have to at some point work for your the person who filed your 485. You have to work at some point. If you've never worked for that company, then it's a problem. But at some point you have to work. And usually when they put a work location, and if it's a consulting company, even if they don't mention travel, if it's different client locations, you're supposed to work. The work location is supposed to be the main office. So if they mention the main office, you're still good. I don't think they're going to look into if the labor is already approved and I-140 is already approved. They're going to look into that as to why the travel requirement was not mentioned there. I don't think they'll look into that.
Okay, so I don't have to move to any another employer just to be on the safe side, or do you advise to file like a 485J with another employer and move so that I won't have any issues at all?
There's no harm in doing that. You're allowed to do that. And you might at some point do your AC-21, right? Because for how many years will you stick with the same employer? That's unlikely. So you will do it at some point down the road.
Okay. Got it.
Thanks, Raj, for calling us. And if you have more questions and would like to reach out to Prashanthi, you can email at prashanthi@readyesq.com or call 212-354-1010 or visit www.readyesq.com. So coming back to our topic, Prashanthi, can we get labor certification filed from more than 2 places?
So yeah, you can have 2 different labor certs as long as it's from 2 different employers. The same employer cannot file 2 labor certs for you. The only way they can do that is if they withdraw the previous labor cert, then they can file another labor cert. But at any given point of time, two labor certs cannot be active with the same employer. But this same beneficiary can file with two different employers. So that is possible. So you do a labor cert with company A, then you do with company B because you have left company A and now have joined company B. In fact, you have to do it because once you leave company A, you cannot use that I-140 to then file your green card, to file the 485. So you need to file the labor again and get an I-140 approved again through the new employer in order to then process your 485 when it becomes current.
Okay. For suppose if a person is presently on H1B and filed I-140 and I-485 is under exceptionality and national approval interest waiver category also. So when he gets an EAD, like I-765 is approved, can he do any part-time job by using this EAD as well as maintaining H1B?
So so that doesn't have to be in an EB1 situation. It can be in any situation where the EAD gets approved, but it's more likely to get approved faster in an EB1 situation because you can file I-140 and 485 together. That's the only difference because visa numbers are available for EB1s. But it could happen in any situation, EB1, EB2, EB3, where your priority date has become current and you file the 485 and you file the EAD simultaneously and now you have an EAD. So yes, you can work for more than one employer when you have an EAD. You're not restricted like you are when you have an H1. The only criteria to follow is that you have to work for the employer that filed your 485 obviously, and through which your I-140 was approved. At any given point of time, your green card your 485 application has to be attached to some employer. You cannot self-sponsor. So in addition to doing that, if you wish to work on your own and do a job on the side, you can do that as long as you are meeting the requirements on your 485 and I-140.
Okay. So can a person and his or her spouse take a part-time job in addition to full-time jobs with the EAD card and when the I-485 is still pending under USCIS?
Yes, again, as I just mentioned, that they can, whether it be a spouse or it be a dependent or it be the primary applicant, it's the same rules. For the dependent, the rules are even better because they can work now with any employer, right? Because they don't have a I-140 approved on their name. They have an EAD and that EAD allows them to work with any employer or multiple employers. They don't have any constraints that the principal applicant has. That they have to work for the I-140 employer. They can work for any employer really. Only the principal applicant has to work for the I-140 employer, and if they want to do another job on the side, they can. But for the dependent, they can really work for any employer or start their own business as well.
Okay. Yeah. So if a person loses his job under H1B status, can he use EAD and get a full-time job?
So if they have a 485 pending, then they do not have to maintain their H1. They can choose to go on 485, and usually I suggest doing that once your I-140 is approved, because if it gets denied, then you lose 485 status, and if you don't have a H1 as a backup, then you will fall out of status and you have to leave the country. So once your I-140 is approved, I don't see any problem in moving to a 485 status, especially if you lose your H1 because you don't have a job with that employer. But then the question is, who has filed your I-140? Is it the same employer? So now you're jobless. So remember, at any given point of time, your 485 has to be attached to some employer in order to maintain 485 status. So make sure you do that.
Okay. So I think we have another caller. Hello.
Hi, Prashanthi ma'am.
Hello.
Yes.
Yes, please go ahead.
Hi, ma'am. Actually, I have a question. So, I have an I-140 approved with an employer A, and I'm actually transferred to another new employer, and actually they are filing my perm and I-140 process now. So my question here is, if in case my labor perm is getting approved, and if I go back to my employer A, do we have to start my process again from the beginning, or will it be the same if I go back to employer A?
So yeah, you can. So basically, you're saying you have a labor and I-140 approved with employer A, and then now you move to employer B, and you want to file labor and I-140 with them, but you want to keep your options open and be able to go back to your previous employer, correct?
Yes.
You can do that, so you can move back to the old employer as long as you file a H1 and transfer it back to the previous employer, and your I-140, as long as it's not withdrawn, you can still use that I-140 to file a 485 in the future. So that will only work if your I-140 is not withdrawn. For the purposes of filing a 485, you have to have an active I-140 which was not withdrawn.
Okay. So it's been long time actually that I got the I-140 with them. It crossed the 6 months gap. So will it still be the same thing, or will
So
there be
there is
any
no
difference?
6 months. AC21 and that 6 months period that we're talking about only applies to people who have filed a 485 and 6 months have elapsed since the filing of the 485. Since you have not filed the 485, there is no 6-month rule that you can benefit from in your case. That only happens once you file the 485. You're still at the I-140 stage, I-140 approved stage, so that doesn't apply to you. So you have to you have to have the I-140 active in order to file a 485. Now it doesn't have to be active in order to file further extensions or to transfer priority dates. You don't have to have an active I-140. You can still use the priority date. But in order to file a 485, you have to have an active I-140.
Okay, got it. Thank you.
You're welcome.
Yeah, thanks for calling us. And if you have more questions and would like to reach out to Prashanthi, you can email at prashanthi@readyesq.com or call 212-354-1010 or visit www.readyesq.com. So coming back to some common questions, suppose if can an employer bench or otherwise render an H1B employee who is non-productive and stop offering the required wage, maybe because of COVID-19 situation or because of that, can he do it?
So it depends on what the situation is. If the person is non-productive, there may be many situations as to why he is non-productive. So it really depends on what the situation is. So for example, if the employer has laid him off because he doesn't have a job for him, then he has to pay him on the bench. But suppose the employee has taken leave because they have some medical problems like COVID, or maybe they were taken extended leave because of maternity issues, then the employer does not have to pay as long as there's no state labor laws which require him to pay under that situation. So that's something to keep in mind. So it really depends on whether the layoff is the non-productive status is because of the employer or because of the employee.
Okay. So just a follow-up question on this, Prashanthi, there are few employers who doesn't pay on the maternity leave. Is it like legal, or is it something that employers have to take care?
So they cannot fire them if they're on maternity. They have to give whatever 3 months maternity. Most states say that you cannot fire someone for being on maternity leave. But not every state says that you have to pay them when they're on maternity leave. So it'll be unpaid leave.
Okay.
So it really depends on the state. It goes state by state. Every state is different.
Okay.
So you have to look up the labor laws of that particular state to see if they have to pay on maternity leave. And again, you can also get paternity leave. It's not just maternity. So even men can get leave when their wife is pregnant or has had a baby.
We have one caller, Kiran from California. Hi, Kiran.
Hello.
Hello.
Hi. Hi. I would like to talk to Prashanthi, Attorney Prashanthi. I have a question.
Yes, please. Yeah, please.
Yeah, sure. My question is, right now the EB3 priority dates are much ahead of EB2. Would the attorney recommend moving to EB3 from EB2? Currently, I'm in EB2. My priority date is like 1 year behind. So what is
So
her
your
advice?
question is, what is my recommendation, whether you should move or not? Is that the question?
Yeah, that's the question.
So there's no harm in filing a new I-140. Don't file an amendment, because then you are closing your options. Then what will you do when if EB2 moves faster than EB3? Because it's difficult to predict what will happen. Things might change in the future. So if you want to file a new I-140 now in EB3, go ahead and do it. There's no harm in doing it, except for the fact that you have to spend time and money doing it. So go ahead and file it, so that if for some reason EB3 becomes current or dates for filing become current, you can at least file a 485 in October, if that happens.
Okay, yeah, sure. That sounds good. I'm working full time, so can I still do another H1, like another I-140?
Yes, absolutely. You can do another I-140. You can do it through your same employer that you're working with, who previously filed the I-140 under EB2. You can do it with the same employer. You don't have to find a new employer for that.
Oh, really? Okay, that sounds great. That's good news to me. Okay, thank you so much.
Right. You're welcome.
Yeah, thanks for calling us, Kiran. And Prashanthi, if a person is a Canadian citizen, so can he come to USA using TN visa or H1B visa?
Yeah, so the advantage of being a Canadian national or a Mexican national is you have some additional options for work visa. For most other countries, it's just the H1, which is best suited. But for Canadian and nationals of Mexico, you also have something called a TN, which allows you to work in the same way that you would work on a H1. And also with less restrictions. So there's no LCA filing, there's no onerous, there's no fraud detection unit coming after you as much as they are in the H1 situation. There's no the strict rules on amendment that is not there, so it's not as strict. And also there, if you are a systems analyst, you can work as a systems analyst or an engineer there. So the positions is not based on specialty occupation that like they are on a H1, so it's slightly different. There is a list of occupations under NAFTA. So if you Google, you will find that list of occupations. And as long as you're under that occupation and you meet the requirements, educational requirements under that occupation, you qualify for a TN. And the other advantage is you do not have to file a petition with USCIS first in order to get a TN. You can get a TN directly at the consulate, or even better, just at the port of entry. So when you're flying in, or you can come by road and you can show the documents, all you need is a petitioner letter, an evaluation, all your degree copies. The petitioner letter will show how you qualify for a TN. So it's very simple to get a TN as opposed to a H1, as you know, with RFEs, etc. It's very complicated and time consuming. So TN is much easier to get when compared to a H1.
Okay. We have another caller, Pradhan from South Carolina. Hi, Pradhan. Hello. Pradhan, you there? Okay, Prashanthi will continue with the question. Is self-employment portability safe under AC 21 180-day portability by the Y memo?
The Yates memo, yeah. So as we were discussing earlier, I think we've kind of covered that. Actually not. You're talking about self-portability. So you're basically saying after 6 months of being on a 485 and after your I-140 is approved as per the Yates memo AC21, you can move to a different employer. But that doesn't mean that you can work for yourself. So self-petitioning is not allowed under AC21. You still have to show that there is an employer and that employer has a job for you and they're sponsoring you, and that they've given you a job offer as per the AC-21 requirements in a job that does not have to be the same but is similar. So no, you can't work for yourself, and a lot of people ask this question, and they think that once they have a 485 and once that 6 months is over and I-140 is approved, they don't have to have an employer. That is not true. You have to have an employer not only until you get the green card, but even 6 months after, so that you can file citizenship after that. So yeah, self-petitioning is not allowed.
Okay. So I think we are back with Pradhan. Hi, Pradhan.
Hi, ma'am. It's Mrs. Pradhan here.
Yes, sir.
Hello,
Please
can you
go
hear
ahead.
me, ma'am? Yeah, I have a question. I'm a teacher. We are filed on H1. So my employee, actually, we were looking for the perm processing. So we approached them for the process. So they said that we are not eligible because our visa states that it is for 3 years. Right now we have a stamp for 3 years, and then the H1 is for 6 years. So they say that we got an email saying that you are not currently eligible for the perm process as your visa currently stands. You are on the H1B visa. So when will be the good time for me to ask for the perm process, and when is actually the perm process can start? So I have this question.
So you have received incorrect information, or you have not understood the information, or there's some misunderstanding, because on a H1B, as long as your I-94 is valid, you can file, even if it's not valid actually, you can file a labor cert, you can file the perm. So they don't look at what your status is when you're filing the perm. They do look at your status if you're filing an I-140, you have to be in status and you have to have a valid I-94. So this is an offer of future employment. Even if you're out of the country, you can still file the labor and I-140. So it has nothing to do with what your non-immigrant status is.
Right. So that's
yeah.
the perm process at this
It
stage
might be,
because yes, ma'am.
So it might be something with reference to the company policy. They don't want to file perm. There might be other factors involved, but it is certainly not a rule of the Labor Department or USCIS that you cannot file perm. You can, as long as you're in status. You should maintain status, obviously. If you're out of status, then there's no point in filing a labor or I-140. Then you'll have to leave and get the green card from outside the country. So yeah, that makes sense to. And visa has nothing to do with it, by the way. Visa is only a travel document which allows you to come and go, into the US. It's the I-94 that is important.
Right.
And you should always maintain an I-94, but that is not a requirement as such for filing the green card for the labor and I-140.
Thank you. Right. Thank you.
You're welcome.
Thank you, Mrs. Pradhan, for calling us. And viewers, if you have more questions and would like to reach out to Prashanthi, you can email at prashanthi@readysq.com or call 212-354-1010 or visit www.readysq.com. So, Prashanthi, if a person OPT expires in August, can he apply H1B visa in this April and stay safely in USA until he gets this H1B approved?
Yes, and that is called the cap gap rule. That's the basis how they apply, and they don't need to file a further extension. So as long as you are in status as of the date of filing, which could be any time after March 30th, March 31st, you get an automatic extension of your status. It's an artificial extension of your status. For example, if you're on OPT, your OPT artificially gets extended, and the way that is done is the DSO. You have to send copies of the filing to the DSO and the receipt, and once you do that, the DSO will extend the status on CIVIS, on the CIVIS website, and that is something that was not there previously. So what would happen is students would have to make sure that they're maintaining their status until October 1st, because remember, even though you're filing it maybe in April, you have to show that you were in status as of October 1st, because the start date is October 1st for the H1, and you're filing it 6 months in advance. So people would have to then file extensions on their F1 just to make sure that they're maintaining status until October 1st. So now that it's not needed, you can use that cap rule. But you have to remember that the cap rule is not an unlimited, does not have an unlimited time. It's either until October 1st or the time that your H1 gets approved. So whichever is earlier. So you make sure that, you make proper use of the cap rule.
So, Prashanthi, this is like a follow-up question. Most people commonly think that we can file green card only when we are on H1B visa or on L1B visa. L1 visa. So, can we also apply for green card when we are on OPT?
Yes, so you can apply for green card on OPT, on H4. So there's some nuances to it, some issues, but those can be easily overcome. For example, on OPT, if you apply for green card, I was telling you, if you're on an F1 status and you have an I-140 approved, you have to tread carefully because there is an intent problem. You cannot have dual intent on an F1 status. So as long as you're not leaving the country, you're not transferring schools or filing for an OPT or doing anything with USCIS, you're fine. But at the moment you do any of these things, then that will be flagged and you will not be successful in whatever you're doing and you might fall out of status. So just remember that when you're filing, you can file a labor, but once you file the I-140, then it becomes problematic to maintain F1 status. So you have to be careful with that. Then at that point, maybe you should change to a H1. Or if your visa number is available, file a 485.
Okay. So we have another caller, Raj from Texas. Hi, Raj.
Hi.
Hello.
Yeah, hi. Can you hear me?
Yes. Yes, please go ahead.
Hi, Prashanthi Garu. Thanks for the help and online help that you're doing. I have two questions. So my two questions are, I did a downgrade in last October from EB2 to EB3, and my priority date is June 2011. So for the client where I'm working right now, they're ready to do my full-time. They wanted me to come on board as a full-time employee, and I'm expecting that my dates will be current next month. So in this situation, one thing about I-140 downgrade, because I'm downgrading it from EB2 to EB3, and my I-140 is approved under the downgrade process on April 1st. So my question is is it okay if I move to the new employer? They are ready to do the H1 transfer and file for 485J. They say they are going to support that. But
so they
thing
cannot,
is,
unfortunately, they cannot file for 485J directly because, so this is the deal. So if you have not filed a 485 yet, have you filed the 485 or no?
Yeah, we did a downgrade.
You filed the 485 in October, correct? In October.
Yes, correct.
Okay. So then is your I-140 is approved, correct?
Yeah, I-140 is approved and it's been 1 month.
And it's
April
been more
1st,
than 6 months now, October, January, February, March,
I-140,
yeah, so
485 filing from on April 27th, it will be 180 days. But I-140 downgrade application is approved last April 1st. So do I need to wait until 180 days from the date the I-140 is approved so that my previous employer won't revoke that one?
It's 180 days from the date of filing the 485.
I'm hearing that if I-140 is downgraded and under EB3, your employer might be having an option to revoke the application. So I just want to make it clear whether they will be having that option or not.
No, they don't have it. Even if they revoke it, you're fine because you can use AC21. But the 6 months should be over from the date of filing the 485. Once that happens, then you'll be free of the previous employer. Until then, you're still stuck with the previous employer.
Okay. Thanks for that clarification. And there is one other question that I would like to ask.
After that date, then you can file that AC21, the 485J with your new employer, as long as the job is similar.
Okay. And the second scenario for the same thing is, so I'm hearing about the dual H1s. So can I maintain H1 with the new employer as well as the old employer until I get DC, and then I can say bye-bye to my current employer? So for
yeah,
that
you can
one,
do
do I
that,
need to
but
do the concurrent or?
Yes, you'll have to file a concurrent H1 and maintain two H1s, but there's no need to do that. Why do you want to go through that?
Because
Two
all these days I
jobs
was
and
thinking like,
So,
I-140 employer will be having an option to revoke the I-140. So I just don't want to have that risk because I still have 4 months for that I-140 180 days clause kind of thing. So that's the reason I was checking for that second option.
So as long as you move after the 180 days, you're fine. If you move before that, then you'll have to do this, as you said, maintain both the H1s and then get rid of the one H1 once you can after the 6 months period is over. Or just move only after the 6 months period is over, then you don't have to worry about the two H1s.
Okay. So this two H1s thing, concurrent H1 you mentioned, right? Is that needed to be applied by the new employer or the old employer that has to mention that it's concurrent?
The new employer. The new employer.
The new employer has to do. And if the new employer doesn't give us an option to do that one, and if they say like it's against the policy and we cannot do that as a concurrent,
then wait for 6 months to get over. Then wait for 6 months. Wait for the 6 months to get over, then move.
Oh, okay. Yeah, I got it. But
there's no reason why they won't do the concurrent. It's the same process. You just have to mark one extra box. I don't see why they'll have an issue unless they don't want you to work for two employees at the same time because there is some confidentiality issue or could be something like that. But unless, from the process point of view, it's the same process.
Okay. Thank you for calling us. And if you have more questions and would like to reach out to Prashanthi, you can always email at prashanthi@readyesq.com or call 212-354-1010 or visit www.readyesq.com. So, Prashanthi, if a person is on EAD and his I-485 is pending in EB3 category, so can he work legally for an employer on 1099 on a part-time basis apart from his full-time job?
So if the EAD is approved, then yeah, it doesn't have to be, you don't have to be on W-2 with the second job. You can be on 1099 as an independent contractor as well. It's not a H1 situation. You have an EAD. So as I said, as long as you are working for the employer who's filed your green card, in addition to that, if you want to work for another employer, you have the freedom to do so. You can even work for yourself as a stockbroker or day trader or whatever. And a 1099 is fine. You don't have to be on a W-2 with that additional employment.
Okay. And for suppose if a person H1B stamping is rejected in Canada or in Mexico, can he reapply in his own country for the same H1B?
Yeah. So yes, you can. Anytime you're rejected, wherever you're rejected, you can always reapply. So yeah, then you'll have to go back to your home country and then apply for a visa there. But obviously you have to see what is the reason for the rejection and see if you're able to overcome that. Sometimes it's rejected because you go to Canada or Mexico, maybe you don't have a US degree, you have an Indian degree, and they're not able to verify that education. So they simply say that go back to your home country sometimes. So in that situation, yeah, then you can, that's the course that you have to follow. You go directly from Canada then to your home country and then apply there.
Just a follow-up question, like which one do you prefer? Like some people say like going to Canada and Mexico and getting visa stamped is better than going to their home country. So like which one do you suggest?
I mean, there's no harm in, it's easier to go to Canada or Mexico, right? Because you can go by road, you can fly, it's a flight, it's cheaper and things will get done faster. But now with COVID now, a lot of people are going to Canada, Mexico because it's not possible to go to India because there are no appointments.
Correct.
But you have to remember right now by road, it's closed for traffic. So you can only fly. You can't go by road. So, something to remember. But otherwise, Canada is more convenient, or Mexico when compared to India. So there's no harm in doing that.
Okay. So when a person is working on L1 visa with a company, and how long can he hold on this H1 visa from another company? And in this case, if the H1 is approved after the L1, like
I
if he has,
don't quite understand the fact scenario, but if the L1, so you're basically saying that
the person
the
has L1 and the person
right,
also got an H1 from a different company. So because L1, with L1 he cannot interchange the companies, but with H1 he can change it. So,
right.
but though he wanted to stay with that L1 company, that A company, he has H1 approved from a B company. So how long can he be in that situation? Can he hold on to that H1?
So I think they should decide beforehand whether they want to be with the L or they want to be with the H, rather than putting their feet into two places and then getting into trouble. Because once you file for a change of status and you request a change of status, and that change of status has been granted, if it's been granted, you have requested that you want to change to a H1. So they looked into it and they granted your request. So now you're on a H1. So as of the date of approval of that H1, you are now in H1 status. So you have to start working for that H1. So if you don't want to work or you've changed your mind, please make sure you withdraw the H1 before it gets approved. Then your status is maintained on an L1. You continue to be on an L1. But don't put your foot in both boats until the last minute. Then you'll be in trouble. You have to make a decision. So if you don't withdraw the H1 before it gets approved, you are unfortunately on H1 now once it gets approved. But also, if it's a cap case, because L1 to H1s are mostly cap cases, right? Because presumably they've never been on a H1 before. Your H1 does not start until October 1st, remember.
Okay.
So you still have a chance, even after the approval, if it gets approved before October 1st, to withdraw it.
Okay.
So as long as you withdraw it before October 1st, you're still on L1. So that's possible. You have a little bit more leeway because you have a future start date on cap case.
Okay. Got it. But like most of them are asking on EB2 to EB3 and EB3 to EB2 downgrading and upgrading and also. Is there any suggestion that you wanted to give to them on this?
So yeah, with reference to the I-140 downgrading or upgrading, my suggestion is to, you don't have to hesitate as long as you're filing a new petition. Make sure you don't file an amended petition because then you have to keep guessing which one is moving, which one is not, what's going to happen in the future, and no one can guess that as to which priority dates will become available and which will backlog. So my suggestion is if you want to do an upgrade or downgrade, make sure you file a new petition, a new I-140. That way you will have two I-140s. Once the new petition gets approved, you will have an EB2 I-140, you will have an EB3 I-140, and you can decide based on what the priority dates are, which one you want to use. You can use either one of them.
Okay. So while a person is on vacation outside the USA, can a person's H1B can be cancelled by the employer?
Yes, can be cancelled, but that does not have any effect on the immediate effect on the employee because they are not in the country. So they don't have to maintain any kind of status. But it does have an effect on their returning to the country. They will not be able to return on that H1. So they'll have to file a H1 through another employer. They'll have to do it consular processing. And then they will be able to use, they'll be able to use the old visa that they have in their passport and the new H1 if they get a new H1 and then come in, using the old visa and the new H1, the new I-797. So that's possible.
Okay, we have another caller, Srinivas from Maryland. Hi, Srinivas.
Hi, ma'am. How are you? Hello, can you hear me?
Yes, we can. Yeah.
Okay, ma'am. So thanks for clarifying all the questions, and I've been following your program for like a couple of times. And my question is, I have a EB3
approved with a September 24th, 2010 date, and following which I also requested my employer to do a EB2. So EB2 is also approved, and with the same, obviously, same priority date of September 24, 2010. And in the recent past, in the month of October, when the dates of filing went ahead, my attorney filed for a 485, and at that time, I didn't insist on filing on EB3 versus EB2, and she did file with EB2, and I did get a EAD in the month of Jan. So far so good. So in the last week of bulletin, the EB3 dates went all the way, I think something like Jan of 2011. So with me having a EB2 and the EB3, would you recommend me waiting for a month or two for the next two bulletins? Because the current EB2 priority date is like August 1st, and my priority date is September 24th, 2010. So there's a gap of 2 months. Would you recommend that I wait for those 2 months, or would you recommend requesting my attorney to? I did hear something about reaching out to USCIS and requesting them to consider my application in EB3 versus the EB2, using which they gave me an EAD.
So there's no rush. I mean, if it's not current right now, why would you want to change? Once it becomes current, then you can request for interfiling at that point of time, because otherwise it's too much of a gamble. How do you know what's going to happen with the dates? And then you'll change it, and then you'll change it back again. How many times are you going to do that? So my suggestion is, once the dates become current, you can request for interfiling. Remember, just because the dates are current for 1 month, no matter what you do, you're not going to get a green card. So the dates have to stay current for a few months, for some time, in order to actually get the green card, because then they might interview you, they might send an RFE, they might ask for updated fingerprints, like anything can happen. And for them to just work on the file, sometimes it takes time. So there's no purpose in changing it simply because you expect that it'll be current for 1 month. So keep that in mind. And also my suggestion is, obviously dates for filing makes no sense to go based on dates for filing. So you have to go based on the final action dates. And if you think that is because dates for filing obviously will not be current, but the final action dates, you're likely to get a green card based only on the final action date. Based on dates for filing, you will not get the green card, right? So if your dates for filing, the final action date is likely to be current, then at that time you should ask for interfiling. And there's no point in doing it in advance. It's up to you, but again, if it's only available for 1 month, it's not useful for you, even if you interfile at that point. So I think if the priority date continues to be available, you have plenty of time then, because it will be continue to be available for the next 6 months or next 1 year, right? Under final action date. So there is no rush now. Once the final action date moves, that's when you can ask for interfiling.
Okay. I hope that answered your question, Srinivas, and thank you for calling us. Thank you, Prashanthi, for answering all our questions. And next week, we will be coming up with more interesting topics. This is Priya Godeti signing off. You are watching Sakshi Manas Sakshi. Thank you.
Thank you.